Hello everyone, this is your host Urvashi Chauhan. Welcome to Courts Today by Live Law, your one-step destination to all legal developments in the country. Let us start. Starting with an update from the Supreme Court, which today dismissed as withdrawn the petition filed by former Jharkhand Chief Minister Hemant Soren, challenging his arrest by the Enforcement Directorate in a money laundering case related to an alleged land scam in Jharkhand. The bench of Justices Dipankar Datta and Satish Chandra Sharma orally observed during the hearing that the petitioner had not disclosed facts relating to the special court taking cognizance of the complaint filed by the Enforcement Directorate. During yesterday's hearing, the bench had asked Soren's counsel, Senior Advocate Kapil Sibal, to convince the court that it has the authority to review the legality of Soren's arrest, even though the trial court had already taken cognizance of ED's complaint and denied Soren's request for regular bail. At the outset, the bench today asked Sibal as to when the petitioner became aware of the special court taking cognizance. Sibal replied that the cognizance order was issued on 4th April 2024 while Soren was in custody. The bench noted that Soren filed a bail application on 15th April. Sibal clarified that this bail application was filed without affecting his arguments in the writ petition. Justice Datta remarked that Soren was pursuing parallel proceedings and stated that the petitioner should have been more transparent about the rejection of the bail and the court's cognizance order. Justice Datta said when the cognizance was taken, the detention became a judicial act rather than an executive act. In an attempt to persuade the bench, Sibal cited judgments to the effect that the order taking cognizance will not stand in the way of release of an accused if the arrest is invalid. During the hearing, Sibal also clarified that the cognizance order was produced as an additional document in the earlier SLP. He also pointed out that Soren's application for bail was mentioned in the present petition too. However, Justice Datta said that it was not mentioned in the list of dates and the synopsis. After the vacation bench expressed disinclination to entertain the matter, the petitioner chose to withdraw the petition. The Calcutta High Court has cancelled all other backward classes, that is OBC certificates issued in West Bengal after the year 2010. The court clarified that those who had attained employment on the benefit of the Act and were already in service because of such reservation would not be affected by the order. A division bench of Justices T. Chakrabarti and Rajshekhar Mantha delivered the verdict in a plea challenging the process of granting OBC certificates in the state. The plea challenged certain provisions of the West Bengal Backward Classes Act of 2012, which made reservations in public offices for those belonging to the other backward classes category. In its order, the court has struck down several classes for reservation as OBC given under the Act. This judgment, cancelling all OBC certificates from the year 2010, is a blow to the ruling Trinamool Congress government, which came in power in the state in the year 2011, because it virtually invalidates all OBC certificates given out under the incumbent government's regime. The verdict is said to affect 5 lakh OBC certificates. The Supreme Court today set aside the Madras High Court order that granted bail to 8 men allegedly belonging to the banned Popular Front of India charged under the UAPA. The bench of Justices Bela Trivedi and Pankaj Mittal was deciding a challenge by the National Investigation Agency against the High Court's order. The court cancelled the bail of the persons, stating that the allegations of collecting funds to commit terrorist acts against them appeared to be prima facie true. It took note of the seriousness of the offences alleged, the period of incarceration being 1.5 years, and the nature of material produced by the NIA, and agreed to interfere with the impugned order. The court further observed that UAPA reflects the endeavour to curb terrorist activities and ensure paramountcy of national security in the country. Thus, the restrictions imposed upon the civil liberties of individuals accused under the UAPA are done in the larger interest of maintaining the sovereignty of India. The court thus set aside the order passed by the High Court and directed the accused persons to surrender immediately to the NIA. The court also directed the special court to expedite the trial without being influenced by any of the observations in the judgment. In veiled response to criticism from economist and member of Prime Minister's Economic Advisory Council Sanjeev Sanyal regarding the Supreme Court's working hours, Justice Dipankar Datta addressed the issue today. He emphasized that those who criticize the judiciary should also focus on preventing delays caused by authorities when seeking court remedies. Justice Datta highlighted the efforts judges make, including working during vacations, and noted the frequent delays in government appeals. He said that the people who are a part of the governance should ensure that at least in one matter filed either by the Union of India or by the state, the appeals should come within time, within limitation. And he said that hardly there is a matter which is filed within limitation, as every matter there is condonation of delay. The remarks came during the hearing of the petition filed by former Jharkhand Chief Minister Hemant Soren challenging his arrest by the ED. In another update, a review petition has been filed against the Supreme Court's ruling which upheld the demolition drive of the Lucknow Development Authority against alleged unauthorized constructions in the Akbarnagar area of the Lucknow city. In the judgment delivered on 10th May this year, the Supreme Court had affirmed the Allahabad High Court's observations and directions pertaining to the demolition and eviction action in the Lucknow Akbarnagar floodplain area. The court had clarified that no slum dweller should be evicted without being given alternative accommodation. Inter alia, in the review petition, the petitioners have argued that the court has not considered the statutory protections afforded to the petitioners under the Uttar Pradesh Slum Area Improvement and Disposal Act of 1962 and Uttar Pradesh In Situ Slum Redevelopment Policy of 2021. As per the petitioners, the scheme outlines a thorough process including the identification of eligible beneficiaries, preparation of detailed plans, obtaining consent of residents, and providing suitable transit accommodation. However, the LDA bypassed the entire statutory scheme and framed the rehabilitation scheme unilaterally and without jurisdiction. The High Court observed that a rehabilitation policy provided flats valued at 15 lakhs to petitioners under the Pradhan Mantri Awas Yojana for around 4 lakhs. The Supreme Court upheld this, noting that Rs 4.7 lakhs payable by the dwellers could be paid over 15 years. However, the review petitioners argued that this payment requirement contradicts the 2021 policy's aim of offering affordable housing and on-site rehabilitation to the urban poor. The Supreme Court has today issued notice in a writ petition challenging a notification issued by the Karnataka government that required the medical students to fulfill 1 year of compulsory public rural service in order to be eligible for permanent registration with the Karnataka Medical Council. The counsel for the petitioner today referred to the Karnataka Compulsory Service Training by Candidates Completed Medical Course Rules of 2015. The scheme mandates that every MBBS graduate, every postgraduate, and every super specialty candidate who has pursued their course of study either in a government university or on a government seat in a private or a deemed university has to render 1 year of compulsory public rural service. Only after the fulfillment of this requirement will the requisite NOC be issued, and this will enable the student to be eligible for permanent registration with the Karnataka Medical Council. Also, as per a 2023 notification, this requirement was extended to candidates enrolled in private seats in private or deemed universities. The matter was today placed before Justices P.S. Narasimha and Sanjay Karol. Justice Narasimha expressed his doubts, saying that just because a student studies in a private college, they would not exempt the person from working in rural areas. He questioned why students from private institutions should be exempt from working in rural areas, and why shouldn't the private institutions contribute to nation building. When the petitioners' counsel submitted that there were bandwidth and language issues, the bench dismissed the concerns, emphasizing the beauty of working in different rural areas across India. The bench has issued notice in the petition. Stay tuned. And now let me tell you, a Kerala court has directed Patanjali Ayurved co-founder Baba Ramdev and its managing director Acharya Balkrishna to appear before it on 3rd June in a case of publishing misleading advertisements in English and Malayalam newspapers. The order was issued by Judicial First Class Magistrate Court in Kozhikode. The drugs inspector filed a complaint against Divya Pharmacy, which markets the products of Patanjali. The case has been filed under Drugs and Magic Remedies Act, which prohibits the advertisement of certain drugs for the treatment of certain diseases and disorders. The specific allegation was that misleading advertisements were published claiming that Divya Lip Balm tablet manufactured by Divya Pharmacy claimed to reduce abnormal levels of cholesterol and fat in the body and to improve fat metabolism. Another one was that the product Nutrella Diabetic Care, manufactured by Patanjali Ayurved, claims to manage blood sugar levels and body weight. Recently, Patanjali Ayurved products were under the scrutiny of the Supreme Court for publishing misleading advertisements against modern systems of medicines like allopathy. The court later issued a contempt notice to Patanjali Ayurved for continuing to publish such misleading advertisements that disparage allopathy and make false claims about curing certain diseases. And lastly, the Calcutta High Court has dismissed an appeal by the Bharatiya Janata Party against an order which restrained it from printing certain allegedly derogatory advertisements against the Trinamool Congress that violated the Model Code of Conduct during the Lok Sabha elections. A division bench of Chief Justice T.S. Sivangnanam and Justice Hiranyamay Bhattacharya expressed concern about the way the ads were published, saying that the BJP as a national party should have an internal system at the centre or state level to approve what can be printed. It emphasized the need for some limits and pointing out that while they are not praising the TMC, the impact on ordinary people is significant. And if parties keep fighting among themselves, the voter ends up being misinformed. Accordingly, the appeal was dismissed upon holding that the court could not go into contentions in appeal which the single bench did not have the occasion to hear, and that the impugned order was merely an interim order. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.